So let's talk about trademarks as a type of intellectual property. We've already discussed in different sections different types of intellectual property, and we know that intellectual property has its basis in human creativity or human ideas that are expressed in different ways. When we talk about trademarks, we're talking about how businesses protect their identities by using words or symbols to let you know that the products or services that you're examining come from a certain business. So the idea of a trademark is to identify the source of goods and services. And that it applies, trademark law applies whether the trademark is registered with the U.S. Patent and Trademark Office or not. Registration is not required, although it's recommended if you're creating a trademark for a business. So what I have on the screen now is the website to the U.S. Patent and Trademark Office, so you can see what registration involves. What happens in the U.S. is someone files a trademark with this office. In order to file it, you also have to search for the trademark as well. And you can see there's a trademark search area where you see whether anyone else has that trademark. And then you go through the process of registration. The website also has information about patents as well, which is discussed in another section. And the idea is, if you look at the tools that you can search for a trademark, when you get a moment, it is interesting to look at what trademarks look like, what you have to file for, etc. Registration isn't required, however, but it's the best way to protect your trademark nationwide. If, though, someone else is using that trademark during the time you decide to register it, it's the first one to use it or the first one to register it who has priority. So it could be that you don't register your trademark until later, and you may not be able to use it in a certain area because someone else is using that trademark or trade name in their area. So, a trademark is a word or a name or a symbol or a device or a combination of those that represent your business. As you can see in the background of this slide, there is a hint of a famous trademark, that is McDonald's. The golden arches, which are more of a symbol that represent a certain restaurant and certain food and ambiance and all of those things that go along with what a trademark is. Now, these golden arches don't really look gold. They look sort of green, but the idea is that to kind of remind you of that particular trademark. So, the first question is, a trademark is entitled to legal protection only if it's registered. Is that true or false? What do you think? Or yes or no? Is a trademark entitled to legal protection only if it's registered? And I'll give you about 10 seconds to think about that. And the answer is no, it's not entitled to legal protection only if it's registered. Protection goes to either the first use commercially or the first to register. However, the unregistered mark is limited to the user's area of use. And so when we say area of use, we're really talking about a geographic area, typically. My favorite example of that is years ago, NBC decided to produce a new logo, which is not new now, it's old, and they've moved on to another one. And it was basically a stylized letter N. Um, so they brought out this logo and started using it. And lo and behold, in Nebraska, there was a public television station that had also had that logo for a lot of years. And so they were the first to use it. NBC could not use their newly created in Nebraska. Think of all the ironies that are involved in that. N for Nebraska, N for the Nebraska Public Television System, N for NBC, which was National Broadcasting System or Company. So anyway, I think that's funny. So in order to broadcast in Nebraska, NBC would have had to block out its logo in Nebraska. So what happened instead is NBC bought the right to be able to use their logo in Nebraska. So at the time, the Nebraska Public Television was one of the richest public television stations in the country. So that's an example, though, of what happens if you have a locally non-registered mark as compared to then someone who's first to register it commercially. Now, what the law does is to, in terms of trademarks, provide more protection for distinctive trademarks versus non-distinctive trademarks. And in this slide, I'm just going to talk about the two major types of distinctive trademarks. Fanciful or arbitrary marks are the most distinctive. So those are words that are made up or words that are real words but are totally disconnected from what the product is that the person is selling. So the picture there is these are the strongest trademarks. And examples are Exxon, Nike, and Apple. Exxon is an invented word, applies to oil. That's fanciful, no connection, completely invented. Nike is also a fanciful type of mark. And then Apple, although it's a real word, it's arbitrary because you wouldn't think of Apple as being a computer. So those kinds of, invented words, symbols to represent your product are the most distinctive, and the law provides the most protection for them. And so that's the reason for the circle with the muscle man arms there. Suggestive marks are not as distinctive as the fanciful or arbitrary marks. So the image is sort of someone lifting up, but not quite up as high as the other distinctive marks. So suggestive marks sort of suggest something about the product or service, and the best example I could read about was Coppertone. Coppertone is a suntan lotion, not something I have to worry about. But Coppertone sort of suggests what the product might be, but it doesn't actually use that same name. I mean, it doesn't actually use the descriptor, but it's just kind of hints at what the product is. So that's still distinctive, but it's not as distinctive as a fanciful or arbitrary mark. Now, there are also non-distinctive marks, and non-distinctive marks, of all of them, get the least amount of protection. In the case of a descriptive mark, the descriptive mark, and I use the same image, but it's the idea that maybe you can get protection for it. It describes some aspect of the product, but the name has to acquire secondary meaning. So for example, Holiday Inn, when you think of vacations and holidays, then Holiday Inn you would think of as just descriptive, but it's acquired a meaning of the Holiday Inn hotels, or motels. So then it becomes protected as a trademark. Vision Center, the same thing. Normally, those are just kind of words to describe part of the product, but they've acquired a meaning of representing that company. And then the generic marks are just descriptive terms that have no protection because they're considered part of the public domain. So if you called your computer company, manufacturing company, computer, that's not going to get any protection because that's a common name that's used for computers. Now, sometimes you may have what you thought was a descriptive name or even a fanciful name, but it becomes part of the public domain. It becomes generic because as a company, you don't do enough to protect it. If you want to make sure that your name is protected, then you have to vigorously enforce that that is a trademark. The examples I've posted here for generic terms are like thermos, which used to be a company that manufactured thermoses, thermos bottles, but they didn't protect the name, so it became generic. Aspirin, the same thing, used to be a company that made it and it became generic. Cellophane, same thing. The image that I have there is of people basically rating the mark 0, which means that there's no protection. That's why I have that image there. I'll give you a couple of examples of where companies are doing the best they can to make sure their mark doesn't become generic. And one is Xerox. How many times have you said, okay, let me make a Xerox of this? Well, if Xerox catches your company saying that, Xerox actively sought out companies and told them not to use that term because they didn't want Xerox to become synonymous with photocopying. And so if your company issued a memo that said, well, make Xerox copies of this memo, and Xerox could discover it, they would contact your company and say, don't say that. Say photocopy, don't say Xerox. The second example is the distinction between Pepsi and Coke. I don't know how many of you have worked as servers, but one of the things that Coke did was to, whenever someone sold Pepsi, to be sure that the servers indicated that they were serving Pepsi and not Coke, because Coca-Cola did not want Coke to become the generic term for that particular type of soda. So if you worked as a server, for example, they would tell you to remind people or ask them, oh, do you mean, or is Pepsi okay, or something like that. And that's the reason for that, is to protect Coke's trademark. So if a company doesn't do those kinds of things, then their trademark could become generic, and if it becomes generic, then anybody can use it. So the term football team cannot be trademarked by the Oakland Raiders. Now, I know some of you might laugh and say, football team, Oakland Raiders, they're not really a football team. Okay, but they are. They are a football team. I'm a Raiders fan, just so you know, so you don't want to make any comments, negative comments about the Raiders. But the question is, the term football team cannot be trademarked by the Oakland Raiders. And let me give you about 5 seconds to answer that one. And the answer to that question is true. Football team is a generic term that describes, different teams in the football, in the NFL, or different, for that matter, amateur football teams. So because of that, the Oakland Raiders cannot trademark that name. That's a descriptive term. It belongs in the public domain. They can't use that. So now the question is, you have a trademark. What if somebody else uses something similar? The question with trademark infringement is whether that use is likely to confuse the public. And if you look at this slide, what I have is like different symbols that say different things. One has an arrow pointing up, another has an arrow pointing to the side, and then there's a triangle with the cross. And then there's a what looks like a yield sign, although it doesn't have any words on it. And I'm trying to show you, give you a visual picture of what confusion is. If something is likely to confuse the public, if your use of a trademark is likely to confuse the public, then that can be an infringement. Or, for a more legal definition, trademark infringement occurs when a person uses in commerce any reproduction, counterfeit, copy, or colorable imitation of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services on or in connection with which such use is likely to cause confusion or to cause mistake or to deceive without consent of the registrant. So I want you to take a minute to think about this one, but before you do, I wanted to highlight that it says registered mark. If you have an unregistered mark, if you wanted to sue someone for infringement, then you'd need to register the mark. So although unregistered mark is protected under trademark law, if you actually want to go into court to sue someone, then you'd register the mark and then sue, because your right to use it is at the time you first use it for commercial use. But if you want to sue someone, then you need to register and then sue. So just take a few seconds and read that definition again. Okay, so we'll move on. Trademark dilution is another type of infringement. Typically, trademark infringement involves competitors in the same industry. Trademark dilution is non-competitors inappropriately using another's trademark in a way that damages the trademark holder's reputation. I'm going to talk about a couple of examples in a minute. So the image I have here is of two people kind of wrestling. They're not necessarily competitors, although they kind of look like it on this image. But the idea of dilution is when someone's not a competitor, but they take and use your trademark in a way that then damages the trademark holder's reputation. And then there are defenses to infringement. Those defenses are parity or fair use or abandonment. There are a couple of others, but these are the key defenses. And so I want to give you some examples. So trademark infringement or dilution. Mutual of Omaha, starting with the one on the left, Mutual of Omaha was a company in Omaha that sells, or not was, is a company in Omaha that sells all kinds of insurance products. Novak created this t-shirt as a commentary on just in general on not just Mutual of Omaha per se, but a commentary on our society. And what he did was call his, on his t-shirt, Mutant of Omaha, and sold, and you can't see it very well on the image, nuclear holocaust insurance. So he sold those in Omaha. And the Mutual of Omaha sued him for infringement of their trademark, not only because of the Mutant of Omaha nuclear holocaust insurance, but also, if you see the logo that he used is a skeleton that's been damaged, sort of hinting that it's damaged as a result of exposure to nuclear waste or something. That contrasted to Mutual of Omaha's logo, which is a Indian chief head. And so Mutual of Omaha, in their trademark infringement lawsuit, argued that that Novak was not only a competitor because they also sold T-shirts. Mutual of Omaha also sold T-shirts and cups and other things through third parties. So then there's competition between Mutual of Omaha's T-shirt and then this Mutant of Omaha's T-shirt. But also the Mutual of Omaha argued it would be likely to then confuse the public. And as part of their proof, Mutual of Omaha produced survey results that showed confusion. So for that, the federal court in Omaha ruled in favor of Mutual of Omaha and said that Novak, who created these t-shirts, had infringed upon their trademark. The second case is LL Bean versus Drake Publishers. And LL Bean, as you may know, sells kind of outdoorsy clothing and other equipment. Drake Publishers produced a magazine called High Society, and it was an adult erotic magazine. One article in one issue, a 2-page article, featured adult erotic entertainment in a LL Bean equipment, for lack of a better description. And so LL Bean sued, arguing that there was trademark dilution because Drake Publishers was doing something that would hurt LL Bean, even though they're not direct competitors. Because Drake Publishing, that's all they did was adult erotic entertainment, and obviously that's not what LL Bean does. So the court looked at it, and the court ruled in Drake Publishers' favor, arguing that there wasn't enough there in the article to show that it had diluted LL Bean's trademark. That the images apparently just showed people camping, but added that adult erotic element to it, but it didn't rise to the level, the court felt, that the public would be confused between Drake Publishing's article and LL Bean. And of course, if you're doing a parody, you're making fun of something, you have to use a little bit of whatever that is you're making fun of so people know what you're making fun of. So the court felt that there wasn't enough there to hold Drake Publishing liable for trademark infringement or trademark dilution. So Mutual of Omaha was successful in its trademark claim. LL Bean was not. So the question, are direct competitors the key types of companies liable for trademark dilution? And I'll give you 10 seconds to answer that. And the answer is no. Dilution is when someone who is not a competitor engages in conduct that harms a trademark holder's reputation. So the dilution is the non-competitors, and the trademark infringement is the competitors. So the last point I just want to highlight without going in any depth, you can look this up, is the Paris Convention and the Trademark Law Treaty of 1994. Both of these are international efforts to recognize a trademark that's created in one country, registered in one country, is entitled to protection in the other countries that have signed these conventions or have signed the treaty. So that's it. Thanks for listening, and I'll see you online.